In today's video, I'm going to talk a little bit about divorce mediation. A common question we get at our office is, should I hire you to be my mediator, or should I hire you to represent me at mediation? I'm Jenny Bradley. I'm the founder of Triangle Smart Divorce, and our team has represented all kinds of folks in divorce mediation. Additionally, I've served as a divorce mediator since 2006. So what I'm going to tell you is today what mediation is, who should do it, who you should pick as a mediator, in my opinion, when you should try mediation, how long mediation takes, why we tell people that we can't be your mediator and draw up your settlement agreement, and who pays for mediation. So let's take the first question. What is mediation? Mediation is when you hire someone that's not representing you, that doesn't have a vested interest in your case or in you, and you hire that person to help you and your spouse reach a resolution about whatever's going on in your matter. That could be custody issues, it could be money issues, it could be property issues, it could be lots of different things. Anything basically related to separation and divorce is what I'm talking about today. Mediation works in all kinds of other cases as well, but I'm focusing on mediation in separation and divorce. So, some people say, do I have to do mediation? Well, the answer is no. If you and your spouse are able to agree upon terms, and you're able to agree upon rights and responsibilities, then I suggest you hire a lawyer to draw that up so it's a legally binding document for you and your spouse. And you don't need to go to mediation because you've agreed. Mediation comes into play when people can't agree, and people need a little bit of help being able to agree. So, who mediates? Well, the answer is anyone can mediate. A lawyer, a therapist, a counselor, a minister, a priest, a pastor. Lots of different people can be mediators. My personal opinion is you should have a lawyer as a mediator. The reason why I think that is because a lot of times in mediations, people ask me, well, Jenny, if I go to court, what's the worst thing that can happen? Or what's my worst case scenario? Ignore the fact that I don't have a crystal ball and I don't really know the answer to that question. I can reasonably advise somebody as to a range of possibilities in court. I don't think someone who has not been to divorce court, I don't think someone who has not been to family court, and I don't think that someone who hasn't been a lawyer can give that same advisory type opinion at a mediation. So that's why I prefer lawyers when I go to mediation to be my mediators. Also, I think it's important to get someone who's a certified family law specialist because they know a lot more about family law. They've taken a test to show that they're a specialist. They also have committed to do at least 12 hours of education every year to maintain their certification as a specialist. But I also think it's important to go to someone who's had mediation training. Myself, I had 40 hours of training, and I also have an annual requirement for additional training to be a mediator through the North Carolina board that certifies me. So I think those three things are important. A lawyer who's a family law specialist, and a lawyer who's a certified mediator through our governing board. How long does mediation take? Well, that can completely depend upon how complicated your issues are and or how agreeable both sides are. So there's no good hard and fast answer there, and it really depends. Sometimes mediation takes several days, sometimes several hours, sometimes we break it up and do it in different sessions in different weeks. It all just completely depends upon you and your circumstances and the other side as well. Here's the big one we get. This is the one that people don't seem to understand because, frankly, it doesn't make much sense to someone who doesn't deal with the state bar. The state bar is the organization that governs my license, the license of the other lawyers here in the firm. So the state bar says I can be a mediator, and the state bar says I can be a lawyer at mediation. But the state bar says I can't be both. I can't be a mediator for two people and draw up a legal document that would be binding on them as their settlement. because in that situation I'm representing both sides of the transaction, and the state bar says I can't do that because even though you're getting along and even though you've agreed to everything, you're technically adverse parties when you're divorcing. And so I can't represent adverse parties. And no mediator can represent adverse parties. This is not a Jenny rule. This is not a Triangle Smart divorce rule. This is the NC bar rule. Likewise, the mediation board says a mediator should not draw up an enforceable contract because the mediator is not serving as a lawyer in that situation. The mediator is serving as a neutral and not a lawyer. So both boards tell us we can't do this. But both boards tell us what a mediator can do is draw up terms of the settlement document, not to be signed, not to be notarized, and not to be an enforceable contract, but more of a summary, if you will. A summary of what the parties agreed to at the mediation, and then the summary can be taken to a lawyer to draft up in a full and final consent order or a separation agreement and property settlement. I know all that's confusing. There's a lot I covered there. We probably need to write a blog piece on that to further explain it. But the bottom line is, if the parties, meaning the spouses, come to mediation with no lawyers, don't get frustrated when the mediator says, I can't draw up your settlement papers for you, because we're prohibited from doing so. But if you bring a lawyer with you, or if both sides have lawyers at the mediation, those lawyers can draw up the settlement documents. Those lawyers can draw up legal binding contracts and consent orders. And then you can walk away with your case settled and not have to go do an additional step after mediation. That's why we also advise that people bring lawyers to mediation, so that when you walk out of mediation, you're settled and you're resolved and there's no real further steps to take. Okay, lastly, people call and they ask, well, I want to go to mediation, but I want my spouse to pay for it. That's fine if you both agree. Most people usually divide the cost of mediation 50-50, or they divide it based upon their percentage incomes, or they agree to use a marital asset to pay for it. But if you and your spouse agree that the other spouse is going to pay for all of mediation, that's fine. It doesn't matter to the mediator. What matters to the mediator is that you guys are both coming here and no one feels that they're at a disadvantage because one person is paying over the other. And that the person who's not paying doesn't abuse the system because they don't have any proverbial skin in the game and they waste a lot of time at the mediation just to run up the other side's bill. That's what the mediator cares about. As to who actually pays the mediator, speaking for myself and myself only, we don't care. We just love seeing people come to mediation and staying out of court because we think two adults can come to a better resolution of their divorce than any judge typically can do. If you have more questions about mediation, please contact our office.